morning. Thank you for joining us. We will call the Senate Judiciary Committee to order. We are busy working towards turnaround here in the legislature. We do have a senator who's testifying right now in another committee. He'll be joining us shortly, and we will get to our order of business. You'll recall on Thursday last week, the committee had a great discussion on Senate Bill 57. I commend the committee for its work and for its discussion. It was a great bipartisan airing of concerns about the bill, both from the prosecution standpoint and the defense standpoint, and what we were looking at as a legislature on this issue. I think it was a good example of how citizens expect their government to deliberate and work on issues. So thank you, committee, for your hard work and your time and effort. As part of that discussion, we learned from the committee that we would like to hear directly from the judicial branch on the issue of speedy trial rights, statutory speedy trial rights, and from the executive branch as well regarding budget issues and things like that. So because of those concerns of the committee, we are continuing now the hearing on Senate Bill 57. I think we're all familiar with the bill, but wanted to have our revisor just briefly comment on what the bill does. And we were looking in committee on Thursday at a proposed amendment. The amendment, there wasn't a motion on the amendment or anything, but also want to commend the prosecutors, the Kansas County and District Attorney Association, and the Kansas Criminal Defense Bar, as well as Sedgwick County District Attorney Mark Bennett, for coming to a written proposed amendment that, in their mind, was resolving the issue of what we're doing with those who are awaiting trial in Kansas, and that trials aren't happening due to the pandemic, and we've got to come to resolution on this issue, and that's why we are looking at it further as a committee. So with that, Mr. Revisor, if you could give us just a brief statement on what the bill does and what the proposed amendment we were looking at would do.
Yes, thank you, Madam Chair. This is Jason Thompson with the Revisor's Office. So Senate Bill 57 amends the statutory speedy trial requirement, and the bill as introduced proposes to suspend the speedy trial requirement for all cases filed prior to the effective date of the act until May 1st of 2024. And the bill also proposes to eliminate the speedy trial requirement for all cases filed on or after the effective date of the act. The proposed amendment that you were considering discussing last time would suspend all criminal cases currently filed or filed in the future until May 1st of 2024, and then give some factors that the court will use when prioritizing cases for trial. I would note that since the committee's discussion the other day, the House Committee on Judiciary adopted that amendment to House Bill 2078, and it is now sitting below the line in the House.
Thank you, Mr. Thompson. Committee, any questions for the revisor? Yes, Senator Haley.
Thank you, Madam Chair. I noted the House's action on the underlying concept in the bill that's before them. Does Mr. Thompson know, Madam Chair, did the House undertake the question of shortening the date from May of 2024? If there was any discussion along that line, I noted that it wasn't in the bill that's before the floor, but did they have any dialogue, or where is that in the House bill? The question of a shorter period between 2020 now and 2024, Madam Chair.
Mr. Thompson, if you can answer.
Thank you, Madam Chair. Jason Thompson again. I was not able to listen to the entire House Judiciary debate that day, but I do know that the May 1st, 2024 date is in the underlying bill. It was in the amendment, and it is what is in the bill as amended coming out of the committee. So if there was discussion, it was not dispositive. They did not change the date.
Thank you, Madam Chair, and thank you, Mr. Thompson.
Thank you, Senator Haley and Mr. Revisor. Committee, I did watch the House Committee's debate on their version of Senate Bill 57. It was later in the afternoon after our discussion. And if you go back and look at the video, the House Committee spent 8.5 minutes discussing it. There were 2 questions, I think, maybe 3 questions, and a comment that while the date was not ideal, it was something that would be supported. So take that for what you will. Again, I go back to my first comment, opening committee today. I commend our committee for the hard work we're doing on this very important issue. So part of the discussion, you'll remember last time we looked at this on Thursday, was what is the judicial branch's plan? If we extend this out as requested or to some shorter date, as some are thinking that we might, what is the plan so that as we're moving forward, we know that this will come to a conclusion, we will get some trials, and what, as in other areas of industry, has been happening, is that happening in the judicial branch as well? We'd asked the executive branch to come and speak regarding the budget, if there are budget items needed to get the courtrooms ready to be open so we can put juries in the voir dire situation where you ask jurors to be impaneled on the jury, to ask them to serve and to be in the jury box. What's being done to get that in place? And the budget has been proposed and suggested, and I believe supported by the governor, so we wanted to be able to ask some further questions on that, just because we as the legislature want to work in unity, if we can, with the other branches of government. And again, I think today is a fine example of that. So I want to thank those who are coming to committee today. And with that, we have the first to speak to committee today on Senate Bill 57. That would be Sean Jurgensen, Special Counsel to Supreme Court Chief Justice Marla Luckert. Thank you, Mr. Jurgensen, for joining us today. Please introduce yourself and welcome again to committee.
Thank you. Can you hear me? Thank you.
Yes.
IT asked me to wait a second so they could give us an opportunity to make it go. Now they tell me that it's live, possibly. Well, and as they're hitting a button, thank you. Madam Chairwoman, members of the committee, I'm Sean Jurgensen. I'm with the Judicial Branch. Thank you for the opportunity to visit with you today about the Judicial Branch's response to the COVID-19 pandemic and the plan that we articulated and that is currently in action for court proceedings across the state of Kansas. But first, a disclaimer. The Judicial Branch is not involved in Senate Bill 57. We can't be. That is a policy decision that we have to leave to our colleagues in the legislative branch to enact, and so we have not been involved in that bill. But nevertheless, we are involved in House Bill 2227 that is in House Judiciary, and that would extend the Chief Justice's ability to her emergency powers under 20-172, her ability to extend or suspend statutory time limits and including statutory speedy trial. But I do want to start with that disclaimer that we have not been involved in Senate Bill 57, but I do want to take the opportunity to discuss our plan. First, some key points, because I'm worried, and we've all worked together before in the past, I'm worried there's a misunderstanding. First, essential court functions have never stopped during the pandemic, not even last spring. And jury trials, not only may they proceed today, but they are proceeding statewide today. In-person proceedings are occurring statewide, remote proceedings are occurring statewide, and this is due in large part to the statutory authority you and your colleagues gave us last spring to hold court remotely, for the Chief Justice to authorize audiovisual communications in court proceedings. And without that authority, we would be in a world of hurt, frankly. And so when we will visit later this morning about virtual court proceedings, but it's more than just virtual court proceedings. In-person proceedings are happening across Kansas, and courts have responded in a number of different ways, including moving court outside, literally outside, as well as outside facilities when a courthouse is constructed in a manner in which you cannot safely conduct a jury trial. And so finally, the final point on this page that I wanted to make is that when we visit with our chief judges across the state, they report no significant case backlog in any area except jury trials. And so I want to start with that understanding that we are, for the most part, current, except for jury trials, for the most part. Some key, and I appreciate that our focus today is on jury trials, but to keep it in perspective, only 1.13% of criminal cases resolve by jury trial. The overwhelming majority of criminal cases resolve without jury trial. We're only talking about 1.13%. And so our criminal cases are moving forward. Don't get me wrong, that 1.13% is a time hog, it's a resource hog, and we invest a lot of energy into conducting jury trials statewide. But in FY19, criminal cases accounted for less than 10% of our total caseload branch-wide. And so system-wide, hundreds of thousands of civil and criminal cases are resolved without a jury trial. Kansas courts have been able to conduct jury trials to protect a constitutional speedy right since May of 2020, and for all other reasons since August of 2020. And the Chief Justice and the Supreme Court have been actively involved in efforts to keep not only court personnel and court patrons safe, but also the public, your constituents, our jurors, and those efforts to protect everyone who is involved in the court system, litigants, attorneys, are memorialized in administrative orders that you can find on our website, which I believe today number already in excess of 50. And they have evolved, those orders, alongside public health recommendations, as all of that has occurred with the pandemic evolving. But like I just mentioned, a key part of our plan and our ability to respond to the pandemic, a key portion of that is codified at 20-172, and that's the Chief Justice's authority to extend or suspend statutory deadlines and time limits, including statutory speedy trial. It also lets her authorize the use of audiovisual communication in court proceedings. But I want to remind the committee that law expires March 31st, and we are coming up on that pretty quickly. Not to give you a spoiler alert, but the Chief Justice, April 15th, the Chief Justice plans to lift suspension of most civil deadlines. And assuming she has the authority to do so, because again, I just mentioned the March 31 expiration date, but assuming she has the authority to do so, she would leave in place a handful of suspensions. Those include 61-3002B, which speaks to a defendant's response time in limited actions cases, as well as the habeas matters found in 60-1501 and 1507. And we do that to protect the health and safety of everybody, while also ensuring access to justice. There are, which are especially present when you discuss self-represented litigants. I also want to visit with you about, this is the website that I mentioned earlier, and I always appreciate the opportunity to visit with you, and you know me well enough that I'll talk to you till I'm blue in the face, individually or as a committee. But all of the judicial branch's plan and how we have responded to the pandemic is available anytime on our website by clicking on that link on the yellow banner across the top. And so it will include all of the resources that we discussed today if you need to go back and pull any of them. But to give you an understanding of how we responded and how we were forced to respond, we have to take a step back in time to mid-March of last year. And I know that we talk about judicial branch budget a lot, but today I want to especially highlight the structure of how the judicial branch is funded. Because while our budget pays for personnel, it does not pay for the operating expenses at the local level. And so our ability to respond with remote work or our ability to conduct remote judicial proceedings was necessarily contingent on the infrastructure that existed in our counties. And the county courthouse and those operational expenses are traditionally a county expense. And so, and candidly, we didn't have the infrastructure we needed to respond. And so without otherwise having the money to respond for that, we had to go looking for it. And we did. So starting last spring, we applied for and received numerous grants to help fund infrastructure within the judicial branch. And what you will look on the screen, what you will see is that we immediately redirected court improvement funds to secure the hardware and software that our employees needed so that we could continue functioning. We received a small reimbursement from the Coronavirus Prevention Fund that you and your colleagues passed in last year's budget bill. We applied for CESF funding, that's the Coronavirus Emergency Supplemental Funding, so that we could purchase key online programs to drive judicial programming that's otherwise available at the courthouse. But because we were dealing with public health directives that limited the number of individuals who could be working, we had to convert our programming to online. And then finally, the largest grant we received was Coronavirus Relief Fund money. And that was approved by the State Finance Council after a recommendation by the Spark Task Force that was convened over the interim. And we received the funding from the Coronavirus Relief Fund, which was just over $3.5 million. We received that in September. And so it took some time. It took some time to make those applications, get the funding. But even when we received the funding in September, it takes time to purchase all of the technology and the plexiglass and the PPE and everything else that you need because everyone else was also attempting to buy that stuff. But I did want to highlight a couple of the things that you may hear about from your constituents, and so that you're not blindsided by any of them. We created, with CESF funds, a protection order portal. These are for some of our most vulnerable Kansans who are seeking protection orders in all of those statutes that we have codified here. And how it works, it's pretty slick, as I understand it. It kind of operates like TurboTax, if you will. When you log in, you can answer a series of questions that the program asks you, and your responses automatically help populate a form that is then submitted to the judge for her to review before issuing relief, or whether the relief is issued. And I think that that's a benefit to your constituents, because what it does is it increases access to justice for your constituents while avoiding any confusion that may accompany legal pleadings or navigating, completing the legal pleading. Other online services that we developed include a marriage license portal. We use CRF funds to develop that in partnership with Inc., as well as ks.gov. And this online portal allows couples to apply for a marriage license without having to visit the courthouse. Immediately when the pandemic hit, we had to limit the number of individuals and the frequency with which folks could visit the courthouse in an effort to help decrease the spread of COVID. And so this portal allows for Kansans to seek a marriage license online and to complete that process online instead of the in-person, paper-driven way that it was before the pandemic. And so I think that that's a benefit. The text notification system I put on there, scheduling court proceedings took on a new life during the pandemic. We had to limit when you're trying to manage the number of individuals in a courthouse or a courtroom, that can become difficult, especially when you have high volume dockets. And so to help solve this, we used Coronavirus Relief Fund money to develop a text notification system, and it allows us to quickly communicate with litigants, if they want us to, they have to opt in, about newly scheduled hearings, reminders for upcoming court dates, and even payment notifications so that they don't lose track of something that the state has asked them to satisfy as an obligation as they juggle all their other bills. And then finally, the grant funding also allowed us to purchase remote technology, something that we were behind on that we needed to catch up with. But like I mentioned, because virtual court proceedings were going to become more and more numerous, we created a virtual court directory, which is essentially one central location that you can go to. I have the website listed there, and with our new statutory authority for AVC use in court proceedings, we didn't want anybody to lose track of where they could find a court proceeding, and so they can go here. It's a one-stop shop, and you can see from the screen that it lists the judge, the court that they're in. You can click on a button next to their name that gives you the docket for that day, and it'll show you whether they're online currently or not. And I'm joined by Chief Judge Glenn Braun today, who is our Chief Judge out in Hayes. That's the 23rd Judicial District. And he has better stories than I have on this, but conversationally, I'm told that watching real-life court TV is a thing, and that people now prefer this over probably cable television's court TV. Come to find out, it's more interesting to watch your neighbors in court than it is complete strangers. And so apparently viewership has been up. But because virtual court proceedings are increasing in number, they presented a number of issues that we had to address. Communicating with litigants, communicating with the public, ways to maximize efficiencies. The list goes on. So the Supreme Court established an ad hoc virtual court proceedings committee, and their sole task was to study and recommend best practices for our courts and everyone who are involved in our courts on using video technology in the courtroom. And you can see that, since we've kicked off with the pandemic, I wanted to juxtapose an urban district with a rural district there on the screen for you. And from March of 2020 to January, Johnson County had about 67,000 remote hearings. It's north of that now because we're at the tail end of February. And then I know Judge Braun will have an updated figure for the 23rd, but the figure I had that was for that same time period up to January was 4,700, which is quite a few for Waukene, Gove City, Stockton, and Hayes. And he can visit with you more on that. But tens of thousands of virtual court proceedings have occurred and continue to occur. But one thing that's really important that we establish is that not only are virtual court proceedings happening, but in-person court proceedings are still happening. And this is a picture of one. This is traffic court down in Wichita. We were visiting somewhat about this morning in Senate Transportation. And like I've mentioned before, judges have moved court outside to continue our court proceedings. And so they are occurring, and they will continue to occur. And these are just like I mentioned, the remote and in person. But I think the major focus of the committee from last Thursday is what is the issue regarding jury trials, and what are the challenges that we are encountering. The first and foremost is that we're responsible with upholding a public jury trial. That's in our Constitution. And so first and foremost, we have to juggle those issues along with all the others that I list on the screen, including upholding, not only upholding that right, but ensuring the safety of everyone who comes to the courtroom, whether they be a juror, whether they be a witness, the attorneys, the parties. And that's because if we don't ensure the health and well-being of everyone who comes, it will destabilize the legitimacy of the court proceeding, and it will bring scrutiny to the overall case and subject it to collateral attack. And so when you bring in large groups of individuals for jury selection, especially in light of the public health recommendations on how this virus has spread. That presents unique challenges that you only experience in jury trials. And so we heard, so to protect everybody, we heard starting about March 16th of last year that our chief judges around the state began canceling jury trials as prospective jurors were calling in saying, we don't believe it's safe anymore to report for jury duty. And around the same time, many county commissions began closing courthouses or issuing stay-at-home orders, and those were happening across the state. And so the Chief Justice signed an administrative order halting jury trials, halting new ones, the ones that were currently occurring in our district courts proceeded until conclusion, and that we placed the courts on emergency operations as an effort to slow the spread of COVID. And so we recognized that nobody should lose their legal rights or be forced to jeopardize their health to exercise their legal rights. And so we responded with a plan. And you can find that plan online, but the things that we wanted to ensure was that our local judges worked hand in hand with your county commissions, with local public health officials, so that they could craft a community-tailored response for their court. And these needs always, and I will say this again, these needs are always balanced against the constitutional right to a speedy trial, and that has always governed in these deliberations. But from mid-March until May 1, courts revamped and allowed remote work to allow for social distancing in courtrooms, and that we directed our judicial districts to develop plans for resuming in-person court proceedings following the public health guidelines that they received from their conversations they were having locally. And our courts have done that. And so it's really important that we highlight those steps we took very early on to create the foundation of these plans that we are now implementing today. And so the plan, by May 27, the Supreme Court had entered an order allowing jury trials to resume when needed to protect a person's constitutional speedy trial right. And it ended that time period where new jury trials were restricted. But that period is similar to or shorter than jury trial suspension orders that you will find in most other states and even at the federal level. Closer to home, as of February 9th, federal courts that, including the Federal District Court in Kansas and those federal district courts that touch Kansas, they have a general continuance on jury trials today. But in Kansas, we are not only allowed to actively schedule and conduct jury trials, but they are occurring. And so I just wanted to juxtapose, that not only are we moving forward, but our colleagues in other states and the federal judiciary, it's a different approach there. And but from the beginning, and I appreciate that there are concerns that there may be defendants waiting on their trial to start. From the beginning, our local judges have worked with county jails, local law enforcement, prosecutors, defense counsel to manage jail populations and to review our bonding practices. And I know that those jail population reviews continue to occur today, and I think Chief Judge Braun, I think he personally does that. He engages in those those jail population reviews out in Hayes in the 23rd. And so the plan is it's listed in a 64-page report. There's also a 6-page summary. The website also includes a video that we produced to give to jurors so they would have access to everything that we're doing to keep them safe, because we're doing everything we can to encourage them to show up and fulfill their civic duty to participate in a jury trial. And you can watch that video at our website by clicking on that link. And so the Supreme Court, in response to the plan, the Supreme Court issued mandates and guidance document, and you can review all these resources, like I just said, on our website. But included in these mandates and guidance documents and our jury task force resources, every one of our chief judges had to craft and submit for review a jury plan. And the jury plan had to include a number of factors, including how they're going to protect jurors and everyone that comes to court, how they're going to communicate with potential jurors during and after the proceeding, securing a jury pool, and the list goes on and on, conducting a fair trial while ensuring participant safety, and then using our pretrial measures to try to minimize the length of time groups of individuals would be exposed to one another. And so those jury plans are rolling in and they are being reviewed, and then judicial districts are conducting jury trials. On the right-hand side, I've listed out some, not all, some, because there's quite a few in that 64-page report, but the jury task force actually provided resources to the legal community, including an outline of all the applicable statutory and case law, so that there are legal resources for folks to look at when they're planning to move forward. It includes a jury trial checklist, a form letter that individuals could use, the courts could use with potential jurors, best practices for those virtual proceedings, and it even includes pictures of a suggested mask, which is right here. And the one on the left, there are these various face shields and see-through masks on what's going to be a best practice for individual courtrooms as they make these decisions. And then on the right, I copy and pasted a sheet of paper. It's an insert that the jury task force created to be sent out with juror summons, because again, we want to remind our communities everything we're doing to keep them safe so that they show up, that they're willing to participate. And so we wanted to provide that to let them know we are working on this. On the left, you will see a picture we received from Sedgwick County. This is individuals reporting for juror duty, and they moved this process outside at this point, probably not the last couple of weeks with how cold it's been. But this is their efforts to ensure juror safety. And you can see that everyone has to be socially distanced, and it necessarily takes longer to do this, as well as there's signs posted everywhere on our courthouses that remind individuals of everything we're doing to keep everybody safe. So, but going forward, and here's a look at a courtroom in Sedgwick County. We all should have invested in plexiglass, come to find out, before this all started. But these are the steps that we've taken to help protect everybody once they're in the courtroom. But going forward, jury trials will look very different. They will move slower, and the jury trial plans include appropriate physical distancing, these barriers or shields, because some Kansas courtrooms are just too small, or they may lack the appropriate ventilation system. And so when that happens, and you still can't take the steps that we've outlined in the plan, we've encouraged our judges to look to outside facilities. And so just a couple, 3 of the examples of outside facilities that our judges have sought out to use. And one of them is actually one of Judge Braun, one of his jury trials that he's conducted. They had to use a VFW building in Waukene for jury selection. In Douglas County, they've used the fairgrounds for jury trials, or at least they plan to. I don't know if one's actually completed yet. And then in Riley County, they had to use a local movie theater in Manhattan for jury selection and a jury trial because the venue is big enough to allow everyone to spread out. And we are working with our defense counsel, our public defender's offices, our county and district attorney's offices on any sort of significant limitation on facilities like this that we're encountering. This is a picture of a counsel table in Wichita. This is not, when I've appeared in court, before I joined the courts, this is not, this is much different than you would otherwise expect when you come to court as an attorney with your client. And again, like I mentioned before, jury trials are moving slower, but they are still resolving. And I know that Judge Braun has specific examples from his district that'll talk about the numbers of jury trials that have resolved because they are actively scheduling them. But I do recall in late January, Mark Bennett, our district attorney in Sedgwick County, he reported that Sedgwick County had resolved 120 cases off their jury trial docket since November 30th. So that would include essentially December and January, for the most part, January. So 120 cases moving off their jury docket down there, as well as the other ones that Judge Braun will highlight. I know that our district court judges are using more and more mediation to help resolve cases as fast as they possibly can. The Chief Justice is assigning senior judges and other judges from around the state, Madam Chair, to go and help judicial districts where they need it so that we can resolve cases as fast as we can. And my understanding is that more and more judges understand the need to use intense pretrial management of these jury cases, which oftentimes has the collateral effect of leading to resolution. And so those are some of the steps, Chairwoman Warren, that we are taking. But jury trials, while they are being scheduled, they are still being continued because of some issues that are just out of our control and out of possibly anyone's control. Because still an insufficient number of jurors report on the eve of trial, even when it's set, someone will come down sick or has to quarantine because they've contracted COVID, like a key witness or a party or even an attorney. I've been told that in some cases, there is a strategy to delay when it comes to a litigation strategy, or quite simply, a community's COVID numbers are too high to safely gather still, even with these precautions that we've tried to spell out. To give you an example of an insufficient number of jurors reporting, it's been 3 or 4 weeks possibly now. The exact date escapes me. But in Abilene, and Abilene is not an urban court by any sense of the imagination. In Abilene, they wanted to conduct a couple of jury trials, and so they sent out jury summonses to their district. Approximately 550 of that community, members of that community, wrote back and contacted the court and said, "We're not coming in. We don't feel safe enough to come in." And one gentleman even said, "If you force me to come in, I'm going to sue you." And so it's this pushback to some degree exists. And so that's an experience we had in Abilene. 550. I mean, that's not an urban court where you would anticipate getting a large number of pushback like that. But again, for the most part, cases are moving forward, and our chief judges report that the only area where we have a significant bottleneck is jury trials. This is Shawnee County on the right and Sedgwick County on the left, and the steps they're taking there. And it took time to get all this stuff purchased. But trial scheduling, like I mentioned, we're doing it at the local level, and to the greatest extent possible to avoid scheduling conflicts, because as everything resumes and has resumed, we're wanting to make sure that we're not necessarily driving scheduling conflicts to add another hurdle to the mix. And then finally, I know that the committee visited briefly about our budget. I hope, it's my sincere hope that the committee appreciates that court proceedings are happening. We're not sitting on our hands and doing nothing, far from it. This year has been a whirlwind experience with everything that we have had to do to continue judicial branch operations. So as courts proceedings have still occurred, we have necessarily also seen a drop in filing fees because case filings are down, and it's primarily driven, you'll see the biggest dip there in May and April because of traffic tickets. Folks, that was during the statewide stay-at-home order, and so people weren't traveling, and so traffic tickets were way down. And so a lot of that revenue will not be recaptured, but the yellow line is 2020, and then the green line is the average over 2015 to 2019, and then 2019 by itself is just the blue line. But you'll see that it's a very big dip from March to the end of June, so the end of last fiscal year. we realized a $2.7 million reduction in anticipated revenue from what we budgeted for that fiscal year. And so what we had budgeted, it actually came in $2.7 million lower because of the pandemic. And then starting July 1, the very next day, through the end of November, that's another $2 million. There's $2 million less in filing fee revenue than based off of 2019, the year prior to that. And so it's off. It's off. It continues to be off. And the only way we've been able to juggle that is by cost-saving measures, including a general hiring freeze. And I only use the word general because there have been a handful of positions that that we had to fill. But what that's done for us to juggle that, because so much of our 91% of our budget is personnel costs, is our vacancy rate has shot up. And like we mentioned in January, it was at 11%, which is more than 1 in 10 positions were vacant. And so that forces our employees to carry the workload of the empty position. And so it necessarily compounds it. And so I would ask for your help, like I've asked for your help every year, in that the judicial branch continues to be underfunded. We're not able to pay our employees what they can command in the marketplace, whether it's a private entity or even a public entity, whether it's the county or the feds. And so we truly need your help. We have done everything in our power to keep court moving. We've created a plan. The plan is in effect, and it's happening around the state. Jury trials are moving, admittedly slower than they used to, but they are moving. And our other case processing, for the most part, is current. And so I thank you. I thank you for the opportunity to come over and present. I apologize that I didn't get over here faster and present on this. That's my fault. But I do appreciate the opportunity. And Madam Chair, usually you ask for questions at the end. Whatever you want. I'll stand for them now, or I'll wait till the end, whichever you prefer.
Sure. Thank you, Mr. Jorgensen, for that very thorough report, and thank you to the judicial branch for all the efforts and processes and activities that they're doing to keep the courts and access to justice rolling. I know it's been difficult, and I'm going to use an overused word that we hear often, unprecedented situation we find ourselves in. I think in the interest of time, we are going to hear from all the 4 who have agreed to present today, and then we will open up for questions committee if we have time. I would ask the other presenters today to please not be repetitive of what we have heard before. And Mr. Jorgensen, if you'll be around for questions at the end, that would be great. With that, then, committee, we will ask Chief Judge Glenn Braun of the 23rd Judicial District, who is appearing on WebEx. Please introduce yourself, Judge, and welcome to committee.
Good morning. I am the Chief Judge of the 23rd Judicial District, which covers Ellis, Rooks, Trego, and Gove counties. It's been described as a rural district. People in Hayes might take issue with that description, but it's a busy judicial district. Just to give you an idea, we ran the numbers in preparation for today's hearing. From March 18th of last year through yesterday, we have conducted 5,657 hearings. This is everything from civil, criminal, domestic, juvenile, child in need of care. We have been working diligently throughout the pandemic, employing the various tools that were described by Sean to accomplish this task. All of our hearings now are broadcast on YouTube, and we have discovered that we are watched far more frequently than we might have imagined. I want to segue into a story. I was doing a domestic hearing. It was a citation in contempt for a ex-husband that had not paid on a property settlement. And it was the second time he had been brought back before the court. I had reviewed his financial statements that were exhibits in the trial, and when he professed his inability to pay his ex-spouse per the agreement, I mentioned that he had a number of rental properties and that he could either mortgage or sell to get the payment made. That afternoon, my administrative assistant was called by the attorney for the ex-husband. And he said, "What's going on?" And she said, "What do you mean?" He says, "I've had 2 realtors call me and ask me for the listings on my client's properties." And we found out that some realtors were watching a domestic hearing, just a typical one that we had. We conducted a murder trial in November. And it was our first jury trial, and it was scheduled because this defendant had been in jail the longest. It was quite an undertaking, and my staff did a unbelievable job in organizing and putting on this jury. It was also broadcast on YouTube to allow public access. We averaged around 100 people a day during the trial watching it live, and had over 3,000 playbacks of testimony during the trial. So what we have learned is where before we would have trials in the courthouse, nobody would attend. Now with the use of YouTube, we have far more public scrutiny of what we do in our courthouse, which means that unfortunately I have to be much better behaved on the bench than I might have been before, because there are people looking over my shoulder. I know the issue before you, the Senate bill, involves jury trials, and we have conducted 2. The murder trial in November, and then we had a Trigo County jury trial on a Jessica Laws case last month. So we have scheduled jury trials and we have conducted them. They provide a lot of challenges, but we have met those. And again, I'm probably going to repeat this, and I want to. The clerks, our court services officers, the court reporter have gone above and beyond the call of duty to get these cases scheduled and tried. I can't tell you how much effort they put forth. Let me give you an example. In the Trigo County case, the voir dire or jury selection was scheduled for Monday after the Super Bowl. That also happened to be the day that we had a significant snowstorm hit. Our clerks, my court administrator and some of the clerks drove on Sunday to Waukene to call the clerks to continue the voir dire. They gave up their Sunday, but they will also let you know they did it early enough to get back to watch the Chiefs. We know how that turned out. But anyway, but they went over on Sunday to call these jurors to delay the jury selection for a day. They sacrificed their time with their family to go do this, and not one complaint. They just knew the need was there and they did it. As far as scheduling of juries go, on my own docket, we have scheduled 31 jury trials this year. Of that, 5 have already pled. So my juries for January, they all pled. The juries for February have all pled. I have a jury trial scheduled almost every week from March through July. Now, will they all go? No. As you heard with D.A. Bennett, once you get them scheduled, a lot of these cases will resolve by plea. But we've now got an equipped courtroom, we have a procedure in place, and we are getting cases to the doorstep. And a lot of time when that occurs, the defendants will take the plea, and that's the result we're seeing. So we're keeping things moving along, and I'm proud of the job that we've done in getting a jury plan approved and to keep these cases moving. You know, the chief judges and other judges have met, and we are very sensitive to the defendant's right to a speedy trial. We understand it and we appreciate it, and we are working diligently to make sure that that right is protected. Because if it's not, we could have defendants going free for serious crimes because of a violation of speedy trial. No judge wants to have that responsibility. And so we work very hard to make sure that those rights are protected. In our jury plan, which was approved, we set up a priority list. So the priority is as follows. If you are Being held in jail on a felony, you are priority number one. Being held in jail on a misdemeanor, I don't believe we have any of those, priority number two. If you're out on bail with a felony charge, you're priority number three. Misdemeanor charge out on bail, priority number four, and civil cases have the fifth priority. So we recognize the speedy trial issue, and our plan accommodates that. We have worked closely with our sheriff to manage the jail population. When the COVID crisis hit, one of the first meetings we conducted was with our sheriff and our jail personnel to talk about how we were going to manage the population in the jail to protect their safety with the COVID, as well as the sheriff and jail personnel's safety. And so we cooperate and work. We email back and forth. I review the jail log every Monday. We see every prisoner that's brought in. The next business day after they're brought in, we get them counsel appointed. We review the charges with them. We see whether bond or supervised bond is available. Our community corrections office here, or community corrections program, runs a supervised bond program, which is a tremendous resource for us, so that we can have people out on bond but supervised. And so we employ all of those methods to make sure that nobody is held or incarcerated without an opportunity to see a judge or an opportunity to be heard. In addition, here's something we've started that we did not do prior to COVID. The old saying, never waste a good emergency, has created a lot of innovations. Currently in Ellis County, we have 1,538 active warrants. Many times our law enforcement people will run across an individual they have a warrant for their arrest, but it may be for failing to appear. It may be for a minor criminal offense. Instead of bringing them into the jail, we started what we call, it may be a misnomer, but an amnesty program. So instead of arresting them and bringing them in on the warrant, the officer hands them a piece of paper that says, here's your court date. Your warrant is still active. Show up this day, or the next time we see you, we'll enforce the warrant and take you to jail. We've had a tremendous response. I only think we've had one or two that I can think of that did not comply with the invitation to come to court and not have the warrant executed. That's something we've started, again, to assist our sheriff and our jailers. So these are just some of the things that we have tried to employ to answer many of the concerns that I heard expressed by members of your committee. We appreciate those concerns. We have the same ones, and we have taken what I believe to be appropriate measures to answer those. So with that, I would welcome any questions you might have at the end of the hearing. Before I finish, I want to at least extend a hello to Senators Wilburn and Haley, who I have the privilege of serving on the Criminal Justice Commission with, Criminal Justice Reform Commission. It's nice to see you again, and most of our meetings have been also remotely or in subcommittees, and so it's always nice to see you again and get an opportunity to visit here today. So thank you, and I look forward to any questions you might have.
Thank you, Your Honor, for your appearing today and for the efforts that your district court and you and your staff and administrators there are doing to get justice, the wheels of justice keep going. Appreciate that. Thank you very much, Your Honor. With that committee, then, we will invite Mr. Will Lawrence, Chief of Staff for the Governor, to the podium. Thank you, Mr. Lawrence, for appearing. Please introduce yourself for those listening and watching online, and welcome to committee.
Hear me? There we go. Thank you, Madam Chair. Will Lawrence, Governor Kelly's Chief of Staff. Thank you for inviting me here today. I'll be pretty brief in my comments and then be happy to stand for questions. I tried to spend a little bit of time listening to the discussion, I think it was last week, and try to spend my time addressing a couple of those issues. First and foremost, I'll say I also have Budget Director Adam Profit with me to answer any questions on the budget. One thing that I'll point out is on the judicial branch budget, the way that works is it comes to the governor through the budget process, but the governor doesn't make any changes. It's passed on to the legislative branch as part of her submission. Same for the legislative budget. So it doesn't go through the appeals process or anything like that. So that budget is as it came from the judicial branch, and they're probably best suited to answer detailed questions, but Budget Director Profit can address some of the questions as terms of the governor and her view on it. In terms of Senate Bill 57 and some of the issues surrounding this, first and foremost, I'd say I think the plan you heard from the judicial branch is a very good one. It's one that the governor supports. Clearly, a lot of time and effort went into all that planning. And the other thing we'd point out is Senate Bill, I think it was Senate Bill 102 from last year, is what provided the Chief Justice the emergency authority to issue orders in conjunction with the governor's emergency declaration being in place. And so I think that is a very good targeted way to address the issue while we're in the emergency. I think the thing that I'd point out is that we're still in the emergency. And it's one of those things where I don't think anyone here wants to still be in that situation. I think we're on day 346, 347 of the response following the governor's emergency declaration issued last year. So, while we're still dealing with these issues, I think it's very, very important. And the thing that I would say, and I've said this before, and I know that we'll be discussing KEMA at some point here in the near future, and I hope to have the opportunity to address that before this committee as well, will be very similar. When we are in the middle of responding to the emergency, it's hard to make very big changes. So where we may want to look at when we're talking about speedy trial, and I am an attorney, but I'm not going to pretend to be well-versed in this issue. I feel at this point I'm more play one on TV than actually practice in my current capacity. We can get into more of that if there are questions about that from the policy side. But in looking at, how far out this may need to go in the date of 2024, something that may be considered is looking at it more towards it still continuing to be connected to the emergency and maybe not being allowed to be extended beyond a certain day as opposed to pushing it out, to 2024 and then pulling it out altogether. That may be a fairly large change that we haven't had a chance to kind of fully vet and look at the situation. And certainly with the COVID-19 pandemic, that's something that once we get outside of this and it's fully done, the vaccines are through that process, the declaration has ended, and things get back at least a lot closer to normal, we have the chance to do a deeper dive and to look at the issues, because there will probably still be more issues that come up between now and that time that will want to be included as part of the overall discussion. So with that, Madam Chair, I would be happy to answer any questions at the appropriate time.
Thank you, Mr. Lawrence. Appreciate that. Mr. Profit, did you want to say something, address the committee, and be available for questions? We'll invite then Mr. Profit, Budget Director, Division of the Budget, to the podium. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Adam Profit, Director of the Budget for the State of Kansas. I do not have any prepared remarks with me right now. I do have details of the budget at a high level. As Will Lawrence stated, by statute, the judicial branch budget comes into the Division of Budget, but the governor is not to amend that, so we simply pass it on to the legislature as it is. Happy to answer any questions that you might have.
Thank you, appreciate that. And just to remind those listening or watching online, the judicial branch budget does not come through Senate Judiciary Committee either. So with that then, committee, we will open it up for any questions for our folks who have appeared today. Yes, Senator Haley.
Thank you, Madam Chair. And first, let me appreciate that you had the foresight, Madam Chair, to extend this part of this deliberation to this crucial branch to hear from the judiciary. Heretofore, as you know, as everyone knows, we hadn't even taken into account who actually are being impacted by this. So I certainly want to extend a sincere appreciation that we get this overview. And I guess an extension of that, or my question would be whether you know or any of the conferees can share if the House has been privy to this insight or to these insights, whether or not Mr. Jurgensen or Judge Braun or anyone has shared what I think has been a most informative perspective from just hearing the conferees today and this presentation.
I don't believe that there was the similar presentation on the House side, but if I'm not correct in that, the conferees can step forward and say otherwise, but not seeing them step forward. I do not think the House was privy to the same testimony that we were.
Well, from my perspective, Madam Chair, they're promulgating legislation in somewhat of a vacuum without having heard, as we've been able to, based on your insight, to have provided for us today. And so that's I guess my editorial comment as we look to the blending of the two bills, probably. My other question is, I guess, is almost probably rhetorical. It would be of either Mr. Jurgensen or Chief Judge Braun. Simply this: once we've established the protocols that are in place, you mentioned the status of different portals for protection orders, marriage licenses, what have you. Post-COVID, after this, do you ever see going back to the way things were a year ago, that we won't be available online, that those portals are not available, that one must actually physically appear, or do you expect to maintain the status quo that we have today that's begun because of this? Are we going to go back to that or not? Do you see that? Madam Chair, Mr. Jurgensen.
You'll go ahead and introduce yourself.
Yeah, sorry, Sean Jurgensen with the Judicial Branch. No, I would anticipate those services remaining. Now that the investment has been made and the services there online and it's working, I would anticipate it staying there.
Here, Mr. Jurgensen, the adjustment in the budget, in the judicial budget, and I appreciate the chart that was the last slide of your presentation. Do you anticipate some means to bridge those gaps between filing fees and other means that have been disaffected because we're doing things differently now and probably will continue after COVID?
So to answer your first question, I haven't given this presentation like I gave for the chairwoman today to House Judiciary, but I did visit about when House Bill 2227 was heard on the House side. We did discuss the emergency powers portion of that then. And then also last fall, the House did receive a briefing through a House leadership letter that Speaker Reichman had requested information from the Chief Justice on. And so as you were asking that question, I was trying to rack my brain on other things that have come up. And but to answer your question, yeah, filing fees have decreased, and the Chief Justice appeared in front of Appropriations on whether or not if there were to be a supplemental budget bill this year, or could we seek to restore some of that lost fee funding so that we could lift our hiring freeze to remove the vacancy rates that we're currently experiencing.
Thank you, sir. Thank you, Madam Chair.
Thank you. Committee, just
Thank you.
a brief note. House Bill 2227 that's been referred to today, I pulled it up, and the proposal is, again, I'm not the reviser, I apologize, but the proposal is in House Bill 227 to extend the authority of the Chief Justice to suspend deadlines, extend that from March 31st, 2021 to June 30th, 2022. And the bill does also say that any order issued to so suspend those deadlines, that order shall remain in effect up to 150 days after the applicable state of disaster emergency is terminated. So again, I'm not the reviser, and if I've totally misstated that, maybe the reviser on HB 227, Mr. Thompson, could speak up. But I think I have the gist of it, committee, that the proposal in the House is to extend the Chief Justice's authority through June 30th, 2022. And with that, then, Senator Pyle had a question.
Thank you, Madam Chair. My question is for Mr. Jorgensen. I want to thank you for the report. It's been just kind of nice to see the work that's been done. On your key points in your presentation, you said essential court functions have never stopped. Do you consider jury trials essential court functions?
Go ahead and identify yourself first, please. Thank you.
Yeah. Sorry, Sean Jurgensen with the Kansas Judicial Branch. So essential court functions have never stopped, but we had to delay jury trials because of the issues that jury trials presented in light of the pandemic. And so there was a pause from mid-March until the end of May where we could not convene jury trials because of the manner in which, as I understand it from public health officials, the manner in which the virus spread. And so until we could take those steps that I outlined in our plan, we weren't able to safely resume jury trials.
Again, do you consider jury trials essential court functions?
Well, I think that jury trials are essential to the rule of law, but when it comes to convening a jury trial, we weren't able to do that safely. Thank you.
But your statement says that court functions have never stopped, and I think that looking at the testimony that we heard last week, it says in September of 2020, Sedgwick County courtrooms were outfitted with plexiglass, which were then approved by the county health director and the Kansas Supreme Court to begin holding up to 2 jury trials weekly, down from up to 5 weekly. But it appears that, according to their testimony, that in September is when they finally were able to actually resume up to 2 a week court. So in essence, basically they did stop. And in that area, they stopped until September. But when we have a constitutional right to a speedy trial, I believe that's essential. I believe the jury trials are essential. I believe that the jury trials, we're going to have to find an answer to getting up to where we were. That's what I want to know is how do we get back to where we were so that we don't have this backlog. And that's what, the issue before us is the bill. And so I'm trying to say, does the court deem jury trials essential? And if so, what's the plan to get back to full speed here, and how long is that going to take?
And perhaps I misunderstood your question initially. Like I mentioned during my testimony, all of those measures were always weighed against a constitutional right to speedy trial. And had a defendant raised a constitutional speedy trial issue, those would have been addressed at the time. But we did have to pause jury trials because of the nature of this pandemic. And so the plan is, and like Madam Chair explained from House Bill 2227, it would seek to extend the Chief Justice's authority to suspend statutory speedy trial because we need time. And so the plan is in place, the plan is moving forward, and hopefully we can work through the jury trial caseload that we have, sir. And we can return ourselves once once this thing finally leaves us, and I cannot wait for that day, truly, that we can move forward at the normal pace like we're used to.
Yeah, well, it sounds like we're having a little bit of difference in our definition of pause and stop, which I've had law enforcement tell me that, you need to come to a complete stop. But it's not a pause, Senator, it's a stop. But it does appear that we had a stoppage in jury trials. And based on the previous testimony, I would think there was a complete stop. And it appears to have happened. My next question, if I can, Madam Chair, and this is just for my own interest, but is plexiglass a PPE?
I don't know.
You don't know?
I don't know. I mean, I don't know if there's a right answer on that. I know that when we applied for all these grants, and my office was involved in helping our chief judges line up all those grants, it would blow our minds how much. I never knew plexiglass cost so much, truly. I should, like I joked earlier that we all should have invested in it. But it's unbelievable, these pictures. It looks like a hockey rink down there. I think that Mr. Bennett, who mentioned that possibly during his testimony or whatnot. But it's unbelievable. It's unbelievable.
Well, I'm just curious, Madam Chair, and thank you for your answers. I'm still waiting for a full compilation of all PPE in the state of Kansas. Thank you, Madam Chair.
Thank you. Thank you. Senator Thompson.
Thank you, Madam Chair. Stay up there, Sean. You note in your key points on jury trials that only about 1.13% of the criminal cases resolved are done so by jury trial. Is that typical for a normal year? In other words, usually it's like 1%.
Right. So we based that off of the FY19 numbers because that was the last year before we had COVID hit that we based that off of. And we didn't want to use 20 numbers because it would have manipulated it wrong because everything we've been dealing with, and I didn't want a story to you. So we based it off the FY19 numbers, and it helps illustrate how few cases actually resolve in jury trial. And Chief Judge Braun mentioned this also. Is essentially once you get them set, they start to resolve, and through those pre-trial case management techniques that our judges are using through mediation, through the assignment of senior judges or judges from other parts of the state, it will resolve. And like Chief Judge Braun mentioned, they are resolving.
So I guess my point is I'm trying to do the math here on what makes sense as a sunset date on this bill. And I guess we heard, I think the backlog was somewhere around 6,000 cases. And if you're applying the 1.13%, that's only like 68 cases. Is that number way too small? And how long would it take to resolve 68 cases? Assuming that most cases get resolved out of court. I'm just trying to figure out, not an arbitrary, but an objective sunset date for this that makes sense.
And I hear you. This is something that I struggle with myself. I don't know the case number out there. I couldn't tell you because part of that equation is how many cases the prosecutor haven't filed yet. And I don't have that figure statewide. And so I can't predict that. But I don't know if there was necessarily a magic to it. But in 2227 that we helped get on file, it would extend it 15 months. The Chief Justice's authority to suspend or extend. And honestly, I assumed that, Madam Chair, if we got to next session and facts hadn't developed, as facts develop over the next year, we would have to, talk about it some more. So that was just my perspective on the bill I was working on. I don't know any magic to it on 57, candidly, sir.
Thank you, Madam Chair. Thank you.
Thank you. Senator Wilborn.
Thank you, Madam Chair, and I want to commend every one of the conferees here today. It was excellent. This committee felt strongly we needed to hear from the judicial branch and the executive branch, and we did, and we appreciate your presentation. I do have a question for the Honorable Judge Braun, right there in the heart of Kansas. You mentioned 5,600 hearings you had since COVID. Can you relate to what that means in relationship to pre-COVID? Is that less, more, about the same, for the same amount of time? And thank you for being here. Thank you for being here.
Senator, I haven't really run the numbers from pre-COVID. In fact, those days seem a long ago. But I would say it's probably pretty typical. I ran it, when I saw the number, I was a bit surprised when my court administrator gave that to me. So I ran the average on the number of work days in that period of time. That's 24 hearings a day. And just as an example, yesterday, I had 14 felony cases that I heard. The other judges together had some trials and hearings. They had an additional 12. So that's about average. We had 26 yesterday. The average for the 5,657 is 24 per day. So I would, and we're running at normal pace right now. So I would speculate which you're not allowed to do in court, by the way, but I can do it in front of this body, I would speculate that that number's pretty accurate pre-COVID and now COVID.
Thank you very much.
Senator Pyle.
Thank you, Madam Chair. And I'm not sure who can answer this question, but I'd be curious to see the number for prosecutions, how many there are and have been for 2020, what there were for the prior 3 years, just to get a number of what we're looking at. Because, I mean, if everybody was staying home, and I don't know what happened to criminal activity during that time period, but if we could see the prosecutions, it might give us an idea. So just curious, up to date. Thanks.
Thank you, Senator. I think we did hear testimony when we earlier heard the bill that bonds were being set as liberally as possible, but prudently, as well as plea bargains. But you're right, I wouldn't know whether that's because there are an increased number of prosecutions or because of other circumstances. It's a good question, though. Senator Corson, did you have a question?
I just had one question, Madam Chair. Thank you. And this is probably for Mr. Jurgensen or Chief Judge Braun. To the extent that we're able to do jury trials right now, do you know whether most districts are prioritizing criminal trials as opposed to civil trials? And I ask that because it would strike me, without wanting to micromanage, that because there is a statutory right, I understand that's been suspended, but there's a constitutional right to a speedy criminal trial. To the extent you're able to do jury trials, it would maybe make sense to prioritize criminal ones because you don't have a speedy trial right to a civil trial. Do you know if that's how most districts are operating? Would either of you be able to speak to that?
Please introduce yourself, who's ever going to answer. Thank you.
Sean Jurgensen on behalf of the Judicial Branch. I didn't know if he was going to jump in. In one of the Supreme Court's administrative orders, the court directed chief judges to triage their dockets, which essentially meant take a look at prioritizing within a scheme, how you're going to address trials moving forward. Not all trials are jury trials, and some matters can, be resolved with a bench trial. And so to the extent I imagine that civil trials are occurring, it probably might be because of that. And Judge Braun, I think, has personal experience because in his jury plan, he does spell out his hierarchy and how they were going to handle that. Thank you, Madam Chair.
There was a comment earlier by a senator today that we don't want to set an arbitrary date, but a date that makes sense. And one question I've had from some constituents, and I'd be curious to know how Mr. Jurgensen or Your Honor Braun would answer regarding if trials have been delayed or paused or stopped or suspended in the criminal context for approximately a year now. I think we said 346, 347 days that we've been in the emergency. So we've got a year of backlog so far, if you will. Why can't those year of backlog be tried in the next 1 year? Because without the pandemic, the presumption of the constituent is, well, you would have tried all those cases this past year and there wouldn't be the backlog. So why does the year of backlog need 3 years out to get caught up to date is the question from the constituent. So I think as we're looking at a date that makes sense, if we could have an answer to that, I think it might be helpful. Mr. Jurgensen or Judge Braun, if you can.
John Jurgensen on behalf of the Judicial Branch. I don't know if I can answer that, Chairwoman Warren. I think that that language is in Senate Bill 57. In House Bill 2227, and I apologize that it hasn't made it to committee yet, and we haven't had a chance to visit on it with me as a conferee. That's what I mean. We asked for the 13-month extension, but again, like I mentioned earlier, I don't know if there was a magic to it on us picking that date, candidly, because I don't know if I can answer the question that your constituent has posed. But
do we know a source that would be able to answer that question? Because I'm assuming May 1st, 2024 wasn't plucked out of thin air. But I understand if you're not able to answer, and if you aren't, you aren't, but where we would possibly look.
One of the, perhaps one of the conferees on the bill when they arrived at that language. I don't know.
Okay, thank you.
Sorry, yeah, I don't know.
No, that's all right. Thank you. Appreciate that. Judge, do you have any thoughts on kind of, we've got a year of backlog, and folks at home are wondering, well, why does it take 3 years to clear a year of backlog?
Well, Madam Chair, I don't know that I have a handle on, but I can tell you from practical experience. Number one, as you know from the presentation, Sedgwick County, for instance, has 2 COVID-equipped courtrooms right now. So they're already limited in the number of facilities they have available to do jury trials. I don't know how many jury courtrooms they had before, but I'm pretty confident it was well in excess of 2. We have 4 courtrooms in our courthouse. Only one of those is jury capable right now with the plexiglass, and part of that's economics. We can't afford to equip every courtroom with plexiglass. Also, it's because of the size of the courtrooms. Certain of those aren't able to be equipped, and for the safety of the jurors. So I think that's part of the problem. The other is we have all the new cases that are going to be filed. Keep in mind that you probably heard from the prosecutors that they may have delayed the filing of certain cases, that now that we're coming out of the pandemic, they may ratchet those back up and file cases. So we're going to have to deal with the new cases as well as the backlog. So I don't really think you can do the 1 year's worth of cases in a year's time because of the new filings that'll be coming in. And I forgot to mention this in my presentation, but I think it's, and I know that the committee is very sensitive to it as well, the safety of the jurors is paramount. And so we have to, the jury selection voir dire process is much more cumbersome than it used to be. We bring in 100 jurors and do jury selection. Now we're limited. We go to an alternate site and we can do 30 per panel. So that takes longer. So even the conduct of the trial itself, because of the more frequent breaks, our jury plans, for instance, in the jury trials we take more frequent recesses so the jurors can get out of their little plexiglass cage and stretch their legs and catch their breath. So all of those things will mean that jury trials themselves will take longer. Plus you have the new cases being filed and the limited courtrooms. And so I think it'll take longer than a year to catch up with the year backlog.
Thank you, Your Honor. That provides me a lot of, are the microphones muted? There we go. Thank you. Sorry, there was echo feedback. That provides me a lot of insight about the physical setup of the courtrooms and why it might take longer, because first of all, there aren't as many physical facilities and locations for the jury trials to occur, as well as voir dire rooms big enough to accommodate the size jury pool that we would need. So appreciate that. And this presents us then with what we try to do in government as the legislature is balance all these interests, keeping the jurors safe, the witnesses, the parties, the judge, the court personnel, and keep the wheels of justice rolling and make sure that rights are protected. So it's our duty as the legislature to deliberate these things and come up with a solution. They're often not ideal, but they are the most informed that we can. We've heard some talk about possible amendments further to the bill, but before we get to that, I want to ask, are there any further questions from the committee for any of the conferees who have appeared today? There was Senator Baumgardner.
Thank you, Madam Chair. This may be for Mr. Prophet. With all of the CARES money that was directed specifically to the courts, has all of that been drawn down?
Could identify yourself and then your response. Thank you.
Adam Prophet, State Budget Director. I was having a hard time hearing. Did you ask if all of the monies that were allocated to the courts out of CARES have been drawn down? I believe Mr. Jurgensen would be able to give a better answer, but we do have line items that add up to the roughly $3.6 million and how that was spent. a large portion of that being on PPE and then some other particulars.
I think we need some clarification for that, Madam Chair, because quite frankly, we know of other areas within just state agencies where money was allocated from CARES funds, but it wasn't spent and was sent back in. We do need a sense, for us to move forward, we must have a sense of where we are as far as courtroom productivity. If we only have 25 or 33 or 50% of the courtrooms that can be utilized for jury trials, that really doesn't give a sense of productivity. And what are the workarounds or the wraparounds? It is concerning to me, we're talking from March to September before, at least in Sedgwick, those courtrooms were ready, and yet we know we've called upon schools and grocery stores and all kinds of different locations to pretty much turn on a dime with regard to plexi and personal protection. We do also need an accounting with regard to what is that triage plan that has been put in place in the different districts, Madam Chair, because with us not knowing that, we could say 3 years, we could say 5 years, but again, what would be the impetus to move forward? Because right now we're not operating at full force. We don't know how much the reduction actually is in day-to-day operation. But one thing that really hasn't been addressed is that domino effect. And so while the individual is waiting for the criminal trial, they're sitting in a jail. And that is an expenditure that was not anticipated. And so we have to know what that's going to be. It serves no purpose to extend a deadline for the Supreme Court, give them an extension if, in fact, our courtrooms are not going to be ready for those jury trials. Thank you, Madam Chair. I do think we need to know the information also about that COVID drawdown.
Sure, if it's okay, Senator Baumgartner, I'd be happy to provide you with the details that the Recovery Office has been tracking as it relates to any CRF funds that went to the court. I would respectfully defer to the court as to, if those funds have been expended and for what, if that's okay.
Well, and along with that, what we need to know from the courts is how much more are they anticipating they need to make the courtrooms operational. Thank you very much.
Mr. Jurgensen, are you able to answer the senator's questions?
Sean Jurgensen with the Judicial Branch. Yes, we have expended our CRF funds that we asked the SPARK Task Force for and that the State Finance Council approved. I am 99.9% certain of that, that we have used those funds to outfit the courtrooms that we possibly can. As far as courtroom productivity, because it takes more space to conduct a jury trial, you'll find instances where they'll use 2 courtrooms to conduct the jury trial instead of just one. So it's not that they've let a courtroom necessarily sit open. It's just that they have to use 2 now to spread out for jury voir dire and whatnot. And that's why, and frankly, it's driven a lot of our proceedings virtually. It's allowed us to keep pace. And like I mentioned earlier, our chief judges are reporting that most areas are current, but it's with our jury trials where we're seeing the significant caseload.
If I might, Madam Chair, I wasn't making an accusation that they're just sitting there vacant. What we don't know is what is the productivity. So if you have 4 courtrooms and you're only able to utilize 2 of them, your productivity is 50%. So what we don't know is what is that throughout the state? What is that reduction in productivity? And without knowing that, again, we really cannot anticipate what would be an appropriate deadline for this particular piece of legislation. We've heard the prosecutors got together and they met with the other side of the issue and started with 5 years, and now it's down to 3 years. But for us to set it into law, we need to know, is 3 years even realistic? And so we are really dependent on, I mean, I saw that criteria was created, task force was put together with regard to the checklist. I don't see a date that was provided, but is there need for additional repurposing or retooling of courtrooms? Have they gone to other vacant areas, spaces, abandoned old Walmart buildings, if you will, dark stores right now? Those would be open spaces, but what alternatives really are we looking at so that we can move? And again, we don't know where we are in a productivity level. We don't know if we're at 50%, 33%. I'm guessing it may be as low as 25% productivity with regard to the jury trials. But until we know where we are now and know really what is the plan ahead for retrofitting or addressing the obstacles that are in place right now, we can't even pass this legislation. We could just randomly draw a deadline, but it has no place in reality right now.
Senator Baumgartner, we did ask our chief judges whether they believed that they could address the pending jury trial caseload that they have. And in response to that, this was last fall when we were preparing for an interim committee. And the response then was, by and large, our medium-sized districts and our lower population districts said, yeah, we'll be able to address our jury trial caseload. That is, I appreciate I'm not specifically answering your productivity statistic, but I'm hoping to get at the heart of the question. And it was really the chief judges that we heard from that said, we're really going to struggle to meet the caseload that we currently have without extension of the chief justice's ability to suspend the statutory speedy trial. And that was by, for the most part, our urban courts, Wichita, Olathe, KCK, Lawrence, and Topeka. And a couple of one-offs. Salina is a medium-sized district that they have a jury trial caseload there. And so I wanted to make sure you had that information too, as you contemplate it. But yeah, it's something I worry about it too, the speed with which we have to move with jury selection because of the public health protocols that are in place and that we have in place to ensure our jurors that we're giving them the safest environment possible. But I understand, yeah, it's moving slower than it used to.
Thank you. The senator raises good questions, good concerns. I would remind the committee that we do need to come up with a solution, whether it's May 2024 or something different. That both sides have come to this well-worked on proposed resolution, proposed settlement. We've heard from the judicial branch and from the executive branch as well, and from the interested parties, I would say, the prosecutors and the defense counsel. Like was mentioned by the vice chair last week, it's not an ideal solution. We'll have entertaining one more question. We are late for other meetings and all, and we will need to be ready to work this bill Thursday, Friday at the latest. So if there are amendments, please have those ready. Senator Thompson.
Yeah, just one quick, to piggyback on Senator Baumgartner's, would it be possible within the time between now and Thursday to get some back of the envelope numbers from these judges that give us their triage numbers? I got one might have 6, 7 cases, one may have a lot more, and then we can kind of look at an average across the state and come to a determination of what makes sense as setting a time. To Senator Baumgartner's, these judges know how long it takes to process. How many cases do they have backlogged? If we could have some real numbers to work with, I think it would give us a lot more guidance into a date to set. that's just a comment. Thank you, Madam Chair.
Thank you, Senator. Would the Honorable Judge Braun be able to work on that with other judges across the state, or Mr. Jurgensen?
I can ask I can ask our chief judges how many pending jury trials they have, or cases that are in need of a jury trial setting, if you will. But that won't necessarily give you all of the cases that haven't been filed yet. And so
Right, that would be
Corey-
just a snapshot of
Right.
where we are this week.
Right.
I think that would help the committee get to a resolution on where we're going to be on the date for this particular bill. I think it's a bill we need to support and proceed with, but we need to do it prudently, and that's why we've had the conferees today and the other testimony we heard prior and the proposed agreement. So if we could have some feedback from the chief judges across the state before Thursday morning or by Thursday morning, that would be greatly appreciated from as many as we can hear from, and we'll proceed with that. With that committee, then, I thank you for your extra time today. It's going to be a long week as we work Kansas Emergency Protection Act, or excuse me, as we hear that bill Wednesday and Thursday this week and Friday as necessary. With that committee, thank you, and thank you for those of you joining us online. We are adjourned.